So the arbitration award, it will have three parts. One is the damages part, which comes out of the adjudication of the disputes. And the second part is cost and interest. So the cost, what is the cost? There are three types of cost in an arbitration. Cost of reference, cost of the award, and then cost of any arbitral institution. If you go to any arbitration institution, and like in India, it is mostly happening ad hoc arbitration. In the sense, party themselves, they either go to an arbitrator like us. If there is no agreement on who is the arbitrator, then they approach the court. The court will appoint. They will approach to the respective high court. High court only can appoint an arbitrator in case of a domestic arbitration. And if it is an international arbitration, then they will approach the Supreme Court. So that is how things are happening. Now we'll see what is the cost of reference in an arbitration award. So cost of reference is nothing but the cost incurred by the parties. Okay, their own legal cost. They'll be appointing counsel and their out-of-pocket expenditure coming and going, expert reports. They are, especially in the construction arbitration, they engage techno-legal consultants like us. That is what we are doing most of the times. We do support services for the construction arbitration in the form of producing independent claim report, such as forensic delay analysis, quantum analysis, and contractual interpretation, technical reports, kind of things. So this cost is substantial if you look at, so they all come under the cost of the reference. Okay. And then witness cost, meeting room hire cost, photocopying and disbursement. Of course, nowadays, everything is soft copy based, cloud based. However, in certain jurisdiction, they need hard copy as well. However, here we must note the cost of reference. It does not include the cost incurred in the respective head offices. Their own management cost, that should not be included. It should be only the direct cost. Okay, direct cost with reference to the ongoing arbitration case. Then cost of the award, what is that? Cost of award, they are arbitrator fee and expenses for the time spent on the reference, including attending hearings, preliminary and interlocutory meetings, visits, and the preparation of the award. So arbitrator fee, it differs from jurisdiction to jurisdiction, institution to institution. That we have seen in the previous sessions. In certain institution, they allow per hour cost also. Okay. And certain institution, they allow based on the claim amount, the percentage of the claim amount. In addition to that, they allow reading fee, because in concession arbitration, there is substantial document is there. So they allow certain reading fee also. Okay. And then if there is a counterclaim, they allow separate fee on that. Over and above, whatever is subsistence expenses, coming and going, lodging, accommodation, so many things. All the expenses associated with the arbitrator, that comes under the cost of the award. Okay. Then fees of any arbitral institution. Of course, in UAE, it is by default, it is happening through the arbitration institution. So arbitration institution, they charge separately the administrative expenses, registration expenses, appointment expenses, because they do the arbitrator appointment. So for appointing the arbitrator, they charge it separately. So all these expenses, they come under the cost of the award. Okay. And now we have seen what are the cost involved in the arbitration award, how they are awarded. Okay. Here, the apportionment of the cost, that concept is not there. Okay. So the general rule in allowing the cost of the arbitration award is that cost follow the event. This you must keep in your mind. Cost follow the event. That means the winning party, he will get the cost of the arbitration. Cost of the arbitration means cost of reference, then cost of the award. That includes arbitrator fee and the arbitration institution's cost. Everything will go to the winning party. So that is the general rule. Cost follow the event. Okay. But however, that is not always. The arbitrator, he has the discretion to apportion the cost in case of improper conduct by the claimant. It doesn't mean that since the claimant invoked the arbitration, he will get it if he wins the case. No. If he doesn't properly conduct himself, if he delays it, if he submits some superfluous documents, we know concession arbitration, already the documents are voluminous. And again, over and above, if he brings some superfluous, unnecessary documents, irrelevant evidences, witnesses, and thereby delaying the proceedings as well as cost. Because in arbitration, it is a very expensive process where time is literally the money. So therefore, the arbitrator in such scenario, he has the discretion to apportion the cost as per the conduct of the parties. So these are the points for awarding the cost. Successful party receives his cost unless cost of a particular application have already been awarded against him during the course of the reference, or he has acted unreasonably and oppressively. He has done something wrongful or improper in the course of events which gave rise to the dispute. That is what I have mentioned. Okay, so a successful party receives his cost unless he has failed to comply with the arbitrator's order for directions, or he has acted during the arbitration in such a way to cause unnecessary argument and expenses. There is an agreement made after the dispute has arisen to the effect that each party will bear their own cost. Okay, end of the day, it is parties' agreement that matters. The claimant has refused an offer to settle equal or to more than the monies awarded to him. That we will see. That already we have seen in the preliminary session, offer to settle. We will see again, just to refresh your memories. Okay, because this is important in your assessment. Effect of an offer to settle. Okay, so during the proceedings, if the respondent, if he makes an offer to settle, and if it is rejected by the claimant, okay, and is subsequently awarded more than the offer or amount paid into the claimant, then the offer will have no effect. Okay, it is as simple as that. Respondent is making an offer, but he rejects it. Claimant rejects it. Once the award comes, they find that the award amount is more than the offer provided by the respondent. Then that offer doesn't have any effect on the cost. On the contrary, respondent, he makes an offer to settle, but the arbitration award, it contains much less than the offer provided by the respondent. In this case, from the date of the offer to settle, whatever the cost incurred, that will go into the claimant's account. Okay, so that is the importance of offer to settle. Okay, so that is what this slide explains. So types of offer to settle, there are few types of offer to settle. First is the open offer, which is known to the arbitrator also. Okay. Second one is without prejudice offer, which is privileged and cannot be communicated to the arbitrator. So that will be a sealed cover offer. Unless both the parties agree, even after the substantive award is made and before the cost award is paid. And then you have sealed offer and you have Calder bank offer. So these are the types of offer provided by the respondent to the claimant. Now sealed offer, what is that? The respondent, he makes a formal offer to the claimant before or during the reference, offering to settle for a specific sum. And he advises that if the offer is not accepted, he intends to place the offer in the hands of the arbitrator. This is known as sealed offer. So now the arbitrator, he will keep it as it is. He should not open it. Okay. The respondent will then hand a sealed envelope to the arbitrator with a request that arbitrator he should not open. That is why it is called a sealed offer. He will open only after he makes his award. Okay. But from that date onwards, suppose if the arbitrator he makes an award much less than the sealed offer, then the cost will go to the claimant's account. Calder bank offer. What is that? Named after it is named after a case law. Okay. That case, this offer was made. That is why it is named after the case law. Case law means judgment. Okay. The respondent, he makes an offer to the claimant in terms of an offer without prejudice except to the cost. Okay. So here he is specifying to the cost. Okay. Cost, they're not, what they're saying, cost will be decided later. Let us see the wordings. Respondent's closing speech in the hearing or closing documents in the pleadings, he makes a request to the arbitrator that he should make an interim award dealing with the substantive liability. That means the damages incurred. Okay. If it is a delay, then the prolongation cost. If it is related to the variation, what are the variation cost? Okay. So consequential losses, etc., etc. So the arbitrator, he will make the respondent, he will make a request to the arbitrator only to make an interim award which deals with the damages. Okay. Not on the cost of the arbitration. Okay. There is a distinct demarcation is there between the damages, substantive liability and the cost of the award. Substantive liability means the remedies which they are seeking. Okay. If it is a concession project, we all know that the time related cost, variation cost, consequential losses, head office overhead, etc., etc. So that is called a substantial liability. So in the Calder bank offer, the respondent, he will make an offer, he will make a request to the arbitrator saying that, Mr. Arbitrator, first you make an interim award only for the substantive liability, not on the cost of the arbitration. Cost of the arbitration, we have just seen. What are the cost of arbitration? That includes cost of reference, then cost of award. Cost of reference means the party's cost, party's counsel, experts, independent expert report, etc., etc. And cost of the award means arbitrator fee, institution expenses, and arbitrator's other expenses. Arbitrator, he may have tribunal secretary. So all these things will come under cost of the award. So the respondent, he will request the arbitrator only to make a award for the substantive liability. Okay. But to make the cost later on. Further hearing to deal with the cost, the existence of the Calder bank offer would be drawn to the arbitrator's attention. Okay. So here what will happen? The same logic. Suppose if the offer is less than the arbitration award, then what will happen? the cost of arbitration will go to the claimant. On the other hand, if the offer is more than the arbitration award, then the cost of arbitration will go to the respondent. Okay. So there is a slight difference between the sealed offer and the callback offer. Here, they will make an explicit request to the arbitrator to split the award into two. First, they will make only the award for the substantive liability, and then subsequently, they will disclose about the callback offer, and based on the outcome of the award, the cost will be determined. Okay. Then interest. Interest is the very contentious issue, and most of the cases, especially the construction cases, they are long-term cases. So the longer the duration, the interest will be more, isn't it? Even though interest is not applicable in jurisdiction like Sharia jurisdiction, nowadays, it is allowed everywhere in different forms, in different text. The arbitral tribunal, they allow interest. So interest is a very, very important element in the arbitration. We have seen, three types of scenarios for the interest. That is the very, very important criteria. The arbitrator, he must know, as well as the parties, they must know. So, just I'm refreshing for your information. So the first scenario is, if the contract says no, no interest. And if the contract specifies a threshold, then the arbitrator, he must act within that threshold only. Nothing more, nothing less. If it says the interest should be so and so percentage, 18% per annum, simple interest, that means he must go only with that, not more than that, not less than the range. However, if the contract is silent about the interest, at this point in time, he acquires the discretion. Now he can award interest at his discretion, but again, only when there is a submission. Only when the claimant asks for it. He cannot award interest without they apply or without they request. So therefore, these three scenarios must be clearly understood. If the contract says no, arbitrator, he cannot award any interest. And if the contract specifies the interest percentage, then the arbitrator, he must stick to that. Okay, nothing less, nothing more. Third scenario, when the contract is silent, then the arbitrator has the discretion to award interest based on the submission. So therefore, it is relevant to all the parties. Suppose if you are the claimant, if you are a contractor, and if your contract doesn't specify the interest percentage, you must be happy. You shouldn't worry about that, because you know very well, arbitrator, he will get his discretion based on what you are submitting. So a diligent contractor, what he will do, he will demonstrate a higher interest rate, which is prevailing in the market. Okay, CERB, the rule for the interest, what it says, normally the arbitrator, he must award interest whenever he gets the discretion. Whenever the arbitrator gets the discretion to award the interest, he can award the interest aligning with the unsecured market interest. Okay, so that is the legitimate right of the claimant, that you must know. If you are a contractor and if your contract doesn't have a provision for interest, that is the best scenario, and there will be substantial amount of interest you can get for your organization, provided you must demonstrate it. It is very simple, isn't it? In your jurisdiction, what is the prevailing interest rate for the unsecured loans? because that is what the international best practices, including CARB, that stipulates. It is a logical one, isn't it? Normally, for a business loan, when you need a business loan, it is unsecured loan. So normally you are getting at a very high interest rate. So therefore, the arbitrator, he must award interest compensating that. So it is interest is a form of compensation. Okay. So that we must keep in mind. Okay. So that's all regarding the cost and interest.